Number 17, Favorite Limited versus Cico.
May I proceed?
Yes.
Good afternoon. May it please the court, Peter Jacob for the appellants. If I could reserve 3 minutes, please.
Yes.
Thank you. First question presented on this appeal is governed by the principles expressed by this court in Rudiger and in the broader principles of the inherent powers doctrine. The principle is that after an appellate decision, the lower court is not just empowered, but it's duty-bound to consider changed circumstances that have changed.
I'm sorry to interrupt you, counsel. Before you get to that, I just want a little clarity about something I'm unsure of regarding this record. The third cause of action, was that dismissed by the First Department in its 2020 order?
No, Your Honor, it was not. And here's how to look at that. You have the October 2018 decision. That's at docket 277 of the trial court. In that decision, page 6, footnote 8, trial court permits the third cause of action to proceed. Then you have the appeal of that decision. You have the briefing and the questions presented. In that case, the Chicos were the appellants. There's an opening brief, there's a reply brief. In none of those documents is there any argument about the third cause of action, which is brought by the individuals only for books and records. And so you move to the March 3rd, 2020 appellate decision. That decision says it's reversing the October 2018 decision insofar as appealed from. And if you look at any of the documents on that appeal, there was not an argument, not a mention of the third cause of action, the individuals for books and records. All the arguments were about the company and its claims.
But they did seek to have the complaint dismissed, correct?
They appealed to the extent they appealed. And every argument in the appeal, every question presented in the appeal was about the company and its claims. And so
But was that not the relief they sought?
they sought to attack those claims that were being brought by the company. Something was wrong with the vote, something was wrong with the resolution, something was wrong with the jurisdiction. The company was not empowered to do what it did.
Well, do you read the 2020 Appellate Division decision on the Second Amendment complaint as saying that the complaint is dismissed?
Insofar as appealed from.
Well, I think the decision, well, all right, the 2022 decision does seem to state that they viewed the 2020 decision as a dismissal of the entire complaint, the pleading, and that is the position of both the majority and dissent. Strikes me if indeed they read the chronology as you do, let me put it that way, that someone would have mentioned that in the majority of the dissent. Did you mention that in the Appellate Division briefing?
Your Honor, in that briefing,
Yes.
there was almost no argument about the decision that the appellate court took. That briefing was about defending an exercise of discretion by Justice Schechter in permitting the amended complaint.
I thought it all turned on whether or not there is a pleading to amend, and if your position is, of course there is, because there's an existing valid third cause of action that was never dismissed, strikes me that one would anticipate there would be some discussion of that in the majority and the dissent below, and that you would put it in your briefing, and that they would argue it in their briefing. I wouldn't end up seeing it only in the reply brief to us, in two sentences, I think.
It is certainly not our primary position with respect to that,
Okay.
adage or catchphrase about there not being a complaint to amend.
Let me ask you, because it is something I'm just trying to clarify in my own mind. Let's say that you are correct, that one looks at the record and says, it may be perhaps that the Appellate Division made a mistake when it characterized these prior decisions as disposing of all of the causes of action. That is to say, dismissing the complaint, right? That the second cause of action was only permitted on derivative claims, not on this third cause of action that the plaintiffs bring on their own behalf, whatever way you want to see that. Can we say, since that is not the basis for the appellate division decision here that's being appealed, that we cannot revisit that issue? We have to take it on, do we have to accept, let me put it another way, what the appellate division says in the decision that's being appealed now? That indeed it had disposed of all those claims, it had dismissed the complaint?
I don't believe it was before the appellate division in that sense. In the initial appellate briefing and ruling, none of this comes up. None of this comes up because none of these arguments were made. And in connection with the second appellate ruling, nobody anticipated a rule of the kind that the appellate division ended up making, and that's under review here today. Rudiger, the principle is that trial court, lower court, is duty-bound to look at changed circumstances different from those that were before the appellate court and form the basis of the appellate decision. And the reason for this rule in Rudiger is because we learned from Judge Cardozo that looking at the changed circumstances, it's not a negation of the appellate decision, it is an enforcement of it. And the prime example is our case here. In our case, after the 2020 appellate decision comes down, job one for the company was to come into compliance with it. And it retained Delaware counsel, went to Delaware Secretary of State, showed Delaware Secretary of State the 2020 appellate decision, figured out how to come into compliance with it, complied. Same thing in the trial court. Job one in the trial court was to make sure that there's been compliance with the appellate decision. Justice Schechter looked at the new certificates from the Delaware Secretary of State, analyzed them against the background of the appellate decision, the 2020 appellate decision, satisfied herself that there is compliance, and only then goes on to the question of how now to proceed.
Rudiger seems slightly different to me, though, in the sense that between the time the appellate division acted and when it got back to the Supreme Court, some facts had changed, which necessitated the courts modifying the relief that was given in the appellate division order. Here, there was no dispute. The fact that the dismissal for lack of standing was made in 2020 was accepted by everyone, including the court. It didn't really modify the appellate division's order. It was a de novo determination, almost, in your case, because now we had new certificates that granted standing where there were none before. Do you see the distinction I'm making?
Not really, Your Honor. Is the question directed to when the changed circumstances
The court
happened?
didn't question this, upon the remitted, the court didn't question the validity of the appellate division's order. It did, it accepted the dismissal and didn't change anything in the order. It then entertained a motion following the issuance of the new certificates. But it just seems like a slightly different scenario between what happened here and what was going on in Rudiger.
Well, it looks exactly the same to me. The circumstances have changed, and the appellate remitter said, dismiss. What was dismissed? What was dismissed was a claim by a company that had been revived prior to the vote authorizing the revival. That's what had been dismissed. Now the circumstances have changed. We have a company bringing a claim that was revived after the vote authorizing the revival. That hasn't been dismissed, so that it's not that the trial court is changing anything about the 2020 appellate decision.
But that revival was not retroactive, right? It was effective as of the date granted? That is to say, there would have still been a period during which the company is not revived, if I can put it that way.
I believe, Your Honor, the way these statutes work is that once you get revival, once you get a good standing certificate from whichever state you're chartered in, it ratifies everything that you've done before that. I know the New York statute works that way. So to complete the thought for Judge Canataro, the trial court then goes ahead with what has not been dismissed, a claim by the company that has been properly revived. Just as in Rudiger, the trial court went ahead with what had not been considered by this court, and that was a number of things: the city's condemnation and also the waste of the natural resources on the land. And so it looks perfectly analogous to me.
Okay.
Yeah. If I could address just the second question presented on the appeal having to do with the statute of limitations. This is governed by the principles of CPLR 3025. Those principles say that when you have an amended complaint that neither offers new facts nor advances new legal theories, it relates back to the filing of the original complaint, and so there is no statute of limitations issue. There is a lot of reference in all three opinions below, as well as in the briefing, to CPLR 205, and let me just explain its relevance. Its relevance is that under 3025, motions to amend, there is no time limit to bring those. There's nothing in the statute about how much time you have to bring those. And so in the exercise of discretion, sometimes some courts look to 205 as a kind of yardstick to determine if that's a reasonable amount of time to bring the motion to amend. And so that's what you see in the cases cited in the briefs. It's motion to amend is timely, a look at 205, it's brought within the 6 months. And so that's what happened here. As a yardstick, we are well within the 6 months of 205. We have about less than 3 months between the time of the 2020 appellate ruling and the time of the motion for leave to amend.
Was there some obstacle to filing a new action?
Was there an
And
obstacle?
you assessed what options you had, and you took a particular choice. I'm not asking about that. I'm asking, was there an obstacle to actually filing a new action, as opposed to seeking an amendment?
Many obstacles, Your Honor, chief among which was the situation in northern Italy in the year 2020. Northern Italy, and specifically the Lombardy region, was the epicenter of Europe's outbreak of COVID-19. The Lombardy region had the highest per capita deaths from COVID-19 of anywhere in Europe. The Lombardy region is where, as we last knew, Carla Cico lived. And so the advice we were getting from Italy Council was that Hague Convention service in northern Italy was not functioning. Hague Convention service in Italy has to go through either the Italy Central Judicial Authority or a local judicial officer, and the advice we were getting was that it is not functioning. Nobody could tell us when it would begin functioning, when it does begin functioning, at what capacity it would function, what a backlog would be. And then, of course, in COVID, many people moved away from where they were, particularly if it was dangerous. Nobody could tell us. We had no idea where Carla Cico actually would be, so that the risk, to answer Your Honor's question, is it's possible we could never again establish jurisdiction over Carla Cico or Benedetto Cico, for that
Did she
matter.
have counsel at that time? Were they also in Italy?
I don't know what her counsel situation is in Italy. My colleague is her counsel here.
Okay.
But we would have to have service of process in a new action. The Chicos have made clear that they would be of a mind to challenge that when the time came. It would be traverse hearing with Italy process service professionals, not to mention the year that it would take to get through this, the $100,000 that it would take to get through this. Yes, there were many obstacles to filing a new action.
Counsel, to just go back to your first point for 1 second before you leave, would it have changed your argument in this case in any way had Supreme Court entered a judgment on the remittitor before the motion to amend?
It would change my argument to answer your question in the sense that it would have changed the process that I used to get the relief.
So it just would have been a different kind of motion? but
Correct.
The same relief, and you don't see any bar post-judgment that would be damaging or fatal to the relief you were asking for?
No, Your Honor. Under 5015, it's directed to the sound discretion of the trial court. 5015B says new circumstances. It says new evidence, but there are cases that interpret it broadly, new circumstances, and good reason for they couldn't have been brought earlier. Prejudice, timing, all of the things that go into the discretionary calculus. So that's what we would have done had there been a judgment.
Thank you.
Thank you.
Good afternoon. May it please the court, my name is Sean Kemp. I'm arguing on behalf of respondents. Your Honors, the First Department majority got it right. After the First Department dismissed appellant's claim in its entirety, there was no longer a pleading pending before the court that could be amended.
Well, let me ask you whether, over here, sorry. So put aside count 3 for a moment. Let's just leave that aside, pretend it didn't exist. There were counterclaims here, right? And so the Supreme Court still had in front of it counterclaims between these two parties.
That's correct, Your
Now,
Honor.
had that not been true, had there been no counterclaims, then clearly I think the appellate division's dismissal order would have been final, right? It'd be a final appealable order, you could have appealed it here.
That's correct,
Right.
Your Honor.
But because of the pendency of the counterclaims, it was not, you couldn't take an appeal here, correct?
That's correct.
Okay. So then, if there's still something pending between these parties in Supreme Court after the appellate division's ruling, why can't the plaintiffs there file, you could even think of it in the form of counterclaims to the existing claims that are there, the exact same thing they filed before?
Because I think that there was an action pending before the trial court, for sure.
Right.
But there was no longer a complaint pending that could be amended. And the motion under 3025B was to file an amended complaint. If the First Department had contemplated that, they could have very simply added with leave to amend or file an amended complaint within a certain period of time. They didn't do that.
They could have, but they didn't say with prejudice either.
No, Your Honor, it wasn't on the merits. There's no dispute there. This was a capacity issue, a standing issue.
So putting aside for a moment the statute of limitations issue, what your position is, I guess, then, is that what they should have done is to file a new proceeding alleging exactly the same things in Supreme Court.
Correct.
Instead of seeking leave to amend to add these claims with the same parties in front of the court that already had them.
Yes, Your Honor, that's how it's contemplated by the CPLR, is that you have the 6 months grace period under 205, and they could have recommenced an action, purchased an index number, and
Shouldn't
there
we be
reason-
concerned
That.
with judicial economy, and why should the plaintiffs have to buy another index number only to have it meet up with this case later on? And doesn't the trial court have some discretion in how to move their calendar, and why should we interfere with that?
I think that the trial court does have discretion to manage their calendar, but I don't think that that trumps the decision from an appellate division. So there is a sense of judicial economy, I suppose, but at the same time, when you look at the fact that the only thing that was pending before the court was our answer and counterclaims, the appellant hadn't even filed any type of reply. They moved to dismiss. So
Is there
while
any-
their motion,
Sorry,
I'm
go
sorry.
ahead. No, go ahead, finish.
While their motion to dismiss was pending, then they went and did the work with the Delaware Department of State, and then a month later or so, they decided to make a motion to amend.
Is there any reason to think that the appellate division had top of mind the counterclaims? And if so, where in the opinion would we see that?
Well, the appellate division affirmed the dismissal of the counterclaims the second time around. I don't think that it was top of mind on the March 3rd, 2020.
That's what I mean.
Yeah, that's correct.
And so, to the extent that their order doesn't take account of those, and those remain in the trial court, is it your position that the CPLR simply won't allow for it, that that's not a sufficient hook in order to allow for an amendment of the complaint? I'm trying to understand why that is.
My reading of the cases and the CPLR is that if there is no longer pleading pending, then there's no
You
motion
would
to amend
distinguish a
that.
pleading from counterclaims, I take it.
The counterclaims were respondents' pleading that was pending before the court. Okay?
So it has to be your own pleading, not your adversary's pleading, you're saying?
That's correct, yeah.
And where in the text of the CPLR, the cases, do you see that limitation?
I think that the issue is established in the case law regarding whether or not a party can amend the pleading after it's been dismissed.
Well, it's the only place where, in the appellate division majority's opinion, when they get to that issue, there's a single case they cite, which is a third department case. And in that third department case, there were no counterclaims. The whole action was gone. So I'm not sure where the authority is for that position, at least not in the appellate division's decision.
I think that one of the reasons why there isn't an abundance of authority on that point in particular, as the facts are set forth in this case, is that most people will go and just commence a new action. So it wouldn't get to an appellate level.
Or maybe it's because they are granted leave in that circumstance to restate the claims they had when they fixed the, non-fatal defect, and nobody cares, because they're going to be in litigation with each other anyway.
I don't think that would be the case, Your Honor, respectfully. I think that when an action's been dismissed, not on the merits, non-merits dismissal, that the appropriate thing to do is to go purchase an index number and commence
Yes,
an
but I
action.
guess you said something a little different before, which is that that's not what people do. That is what people do in the circumstance where there still are counterclaims pending. They pay the extra fee instead of just joining it in the existing action between the same parties. I don't know that.
I don't know that to be the case either, Your Honor, but I know that there's provisions made in the CPLR for exactly what happened here. And making a motion for leave to amend is not the same as commencing an action under 205.
I mean, there's no question that the Supreme Court still has jurisdiction over the parties because of the pendency of the counterclaims, right?
That's correct.
Okay.
Well, on the counterclaims, who are the parties? Is
I'm
it-
sorry.
Who are the parties? Is the company a party in that counterclaim?
The individuals,
Yes.
the individuals are a party.
But is the company a party?
I don't believe so,
Favorite
Your Honor.
Limited, and I know there's another company, but that's the company we're really talking about.
Yes, I don't believe so, Your Honor.
Okay. What's your position on this issue I was asking about before regarding the third cause of action?
My position is that the complaint was dismissed in its entirety. That's what we were seeking, and that the third cause of action went out with the dismissal.
But it does, perhaps I've misunderstood Supreme Court, but it does seem Supreme Court didn't see it that way. There's a bit of tension there, I agree, because I do think Supreme Court recognizes that it's a dismissal, but there are various notations about this third cause of action. And it is set forth in the second amended complaint, it's set forth in the third amended complaint.
It's set forth in both complaints, you're correct, Your Honor. However, I don't think that the appellate division made any distinction when it rendered its decision, and it said that the action was dismissed in its entirety. It was an unconditional dismissal. Like I had mentioned before, they could have said very easily, dismiss with leave to amend.
Or-
But
Yes,
that-
or these causes of action against these parties are dismissed. Was this issue about that third cause of action raised in the briefs to the appellate division? Again, he raised it in his reply.
No, Your Honor, I don't believe that third cause of action issue is raised in any of the briefing.
Thank you.
If there's nothing further, I'll rest on my papers.
Thank you.
Thank you.
Just very briefly, to respond to Judge Rivera's question, it's in the record at 57, first counterclaim, breach of operating agreement against Upper East Side Suites. That's the company. The company is party to the counterclaims. A simple answer. I wish all the answers were so simple.
Thank you. I'd like to follow up on some of these questions regarding the counterclaims. Let's assume for one moment the complaint is dismissed. Let's put aside this third cause of action issue. Could you have moved to amend if all that is pending are counterclaims? What would be amended?
It's an excellent question, and it comes from this adage that we see in the decision below. We heard counsel just say, no pleading left to amend. Okay? I tried to touch on this in the briefing, that adjudication by catchphrase like this is usually not the best idea. You have to get beneath the catchphrase, see what its origins are, what are the principles underneath it, how do they apply to your case.
But isn't he correct textually that the CPLR does speak of pleadings? I mean, Supreme
Yes,
Court
certainly.
referred to the action, but that's not what the CPLR says.
This adage that there's no pleading to amend, it conjures the image of a claimant who is looking for the pleading to physically try to amend it. That's not what goes on. What goes on is the claimant comes with a revised pleading and asks to be permitted to proceed with it. And the question is,
And
should...
at that point, there isn't a pleading because the court has already dismissed it, right? Right? In your typical, forget about an appeal, right? You're just in Supreme Court.
Okay.
The defendant moves to dismiss, right? And it's past the 20 days, so you've got to get leave to amend. Defendant moves to dismiss, court grants the motion to dismiss, and grants leave to amend the pleading. When the court dismisses the pleading, there isn't any pleading any longer, yet you can still amend it.
Precisely. Dismissed pleadings are amended every day. This happens normally. This adage that there's no pleading to amend it's a terrible adage, and it should be disapproved. The question is, should you be allowed to proceed with your amended pleading or not? And if it was a dismissal on the merits with prejudice, like each one of the cases that uses this adage is, that's a threshold question, and the answer is going to be no. There are ways to get relief from dismissals with prejudice, but
Yeah, but you can,
3025
I
is not
understand
one
your
of them.
point there about amending something that was dismissed, coming back to the well, but it depends on what you want to amend it for. So we're back to my question before about the resuscitation, if you will, of this company.
The answer to your last question is yes, the counterclaims are another hook for what should be amended. The answer to that is yes.
But your view is, I take it, is that any dismissal without prejudice, provided that there's no entry below, can still be amended notwithstanding the appellate division's dismissal?
No, my position is that it can be brought to the court for exercise of its discretion.
Yeah, but the court has discretion.
Has discretion.
In any circumstance, even where the appellate division dismisses, provided that it's without prejudice.
It's very circumstance specific, but yes, Rudiger says if there's changed circumstances, yes. The inherent powers doctrine says if it's about docket management and litigation management before the trial court, like this case is, then yes, the trial court should always have discretion to say whether it's going to proceed with a new action or an action in the existing case where everybody is already a party, where there's been lots of rulings in the case already, important ones, where discovery is more than half done.
No,
and
but
in a
again,
case that has...
doesn't it turn on what it is you wish to correct? And it's whether or not that can be corrected through an amended pleading. The appellate division's position was no. At that point, the only corrective action you could have taken was to file, you dealt with the certificates, but then then you have to file a new action, right? That's the import of that.
I don't see why that would be the case. You certainly have to comply with the substantive ruling of the appellate decision.
Because-
And that's what we did.
Because at the time you filed, you didn't have standing. And you can't cure that. You can't go back to correct that. I understood the appellate division to be, majority, to be taking that position. You cannot correct that, other than by addressing the standing issue, and then you file again.
Addressing the standing issue and then coming to the court and asking to proceed, now that the
Except
standing
that
issue has
doesn't
been...
cure, as I understood the majority, that doesn't cure the actual basis for the dismissal. The basis for the dismissal was you didn't have standing at the time you filed. And that cannot change. You may now be in a position to be able to file a claim, but you didn't have it at that time, and that's why that's dismissed. That's how I understood the majority, and I just want to be clear on what your response is to that.
I'd like to respond to exactly that.
Yes.
The company had standing when it filed the action. There came a time when Mr. Cico resigns quietly, without telling anybody, at the Delaware Secretary of State as the person authorized to accept service of process. That resignation resulted in the loss of good standing at Delaware Secretary of State, happened in the middle of the case. The Chicos, in one of their many motions, brought that to the court's attention. We addressed it. We addressed it the way we thought we were supposed to address it: go and put somebody else in that position at the Delaware Secretary of State, and then proceed. The 2020 appellate decision said it happened in the wrong order, should have voted first, revived second. We disagreed with that, but we acknowledged that it's binding, and we went and complied with it. So our compliance should relate back to the very beginning.
Thank you.
Thank you, Your Honor.